You know that feeling. When you're handed a stack of complicated paperwork, maybe after a really difficult time, and it's full of words like probate and estates.
Oh, absolutely. It can feel incredibly daunting, like trying to navigate a maze blindfolded.
Right, and the language itself, it's almost like a different language altogether.
It really is. It's a specific legal system, and,
Yeah.
you're often encountering it during times of major stress or loss.
Exactly. So our goal today in this deep dive is really to try and clear some of that fog. We're focusing specifically on Maryland's estates and probate system,
Hmm.
and we're drawing our insights from material provided by attorney Matthew Dyer at the law offices of Haskell and Dyer.
Right, and it's worth noting they have a real focus on Southern Maryland.
Yeah.
So we're talking Anne Arundel, Calvert, Charles, St. Mary's, and Prince George's counties.
Good point. So if you're dealing with an estate connected to that area, this should be particularly relevant for navigating the local system.
Def.
So our mission here is to take this, let's face it, complex topic, break it down a bit, talk about the key players, the processes.
And really shine a light on those situations where getting some knowledgeable guidance isn't just, helpful, but pretty much essential.
Absolutely. Let's start unpacking this.
Okay, where should we kick off?
Let's go right to the core. What is probate in Maryland? What does that term actually mean when we're talking about this?
Okay, so probate, or sometimes it's called estate administration, it's basically the official legal process that happens after someone passes away.
The official process.
Yeah, it's how the law makes sure that the person's property, their assets, like, their house, bank accounts, personal belongings, are all properly managed and eventually distributed.
Okay, so it's the formal legal sorting out process, essentially.
That's a good way to put it.
Yeah.
Precisely. And the main goals are always pretty much the same. First, gather up all the assets.
Identify everything.
Right. Then pay off any valid debts or taxes the person owed. And finally, make sure whatever's left over gets transferred correctly to the rightful heirs or beneficiaries, people who are legally entitled to it.
According to a will, or maybe state law if there isn't one.
Exactly. Either way, it ensures things are handled properly.
Got it. So who are the main players then? The key institutions here in Maryland that oversee all this?
Well, the main court for probate matters in Maryland is the Orphans Court.
Orphans Court. That name always throws me a bit.
Yeah, it's a bit misleading. It handles all estates, not just ones involving children. Every county has one. Although in some of the smaller counties, circuit court judges actually handle these duties instead.
Okay.
But the Orphans Court's main role is supervising the administration of estates, especially for assets that were held just in the deceased person's name alone. Sole ownership.
Ah, okay. So things like jointly owned property or maybe assets already in a trust, they might not fall under the Orphans Court's direct supervision in the same way. Is that right?
That's a really critical distinction, yeah.
Yeah.
Assets that pass automatically outside of probate, like through joint ownership with right of survivorship, or maybe life insurance payouts with a named beneficiary, that kind of thing,
Mm-hmm.
they typically don't need Orphans Court involvement. The court really focuses on the assets that do need that formal administration process.
Makes sense.
They're also the ones who grant the legal authority to the person who's going to manage the estate, the personal representative. They help resolve disputes if they come up, and they oversee guardianships, but specifically for a minor's property.
Guardianships of property for minors. Okay, tell me more about that. So if a child inherits, say, a significant amount of money.
Exactly. The Orphans Court steps in to make sure it's managed properly for the child's benefit. They can appoint a guardian whose specific job is to manage those inherited funds or assets until the child turns 18.
So it's like a protective measure built right into the system.
It is, absolutely.
Yeah. Okay, so the Orphans Court is the supervisor, the ultimate decider on contested stuff. But what about the Register of Wills? That office seems really central, too.
Oh, essential. The Register of Wills works very closely with the Orphans Court. There's an office in each county, and they primarily handle what's called administrative probate.
Administrative probate. Okay, how's that different from what the Orphans Court does? Is it like a first step?
Think of it this way. The Register of Wills handles the more routine, uncontested cases. When an estate is pretty straightforward, everybody's generally in agreement, the paperwork looks right.
Okay.
The Register of Wills office can process the administration. They handle the filings, help get things started, and can often formally appoint the personal representative without needing a full court hearing in front of an Orphans Court judge.
So administrative probate is sort of the smoother path for estates that aren't generating conflict or big legal questions.
Basically, yes. It's the more streamlined approach for clear-cut situations. Now, when you get into estates with complexities, maybe challenges to the will, disputes between heirs, significant legal questions that need interpretation,
Right.
those matters get elevated to the Orphans Court itself. That's judicial probate. That's where the judges step in, hear arguments, look at evidence, and make rulings to resolve the conflicts.
Okay, that distinction is really helpful. Register of wills for administrative, straightforward stuff. Orphans Court for judicial, more complex or contested issues? Makes sense. Now, the path forward obviously depends hugely on whether the person actually left instructions, right? Did they have a will?
Absolutely. That's fundamental. If there's a last will and testament, it must be filed with the Register of Wills in the county where the person lived.
And that document does what, primarily?
Two critical things, mainly. First, it names the personal representative, that's the person often called the executor, who's tasked with managing the estate.
Okay.
And second, it specifies who inherits what assets, the beneficiaries.
But just having the will isn't enough, right? It doesn't just automatically take effect the moment someone passes away.
That's a crucial point. So many people miss this. In Maryland, the will only gains legal power, legal effect, once the Orphans Court officially admits it to probate.
Admits it to probate.
Yes. It's the court's validation process. They confirm it's legally sound, properly signed, witnessed, and that it's the most recent valid will.
Okay. And what if there's no will at all? If someone dies intestate?
Right. Intestate means dying without a valid will. In that case, Maryland law kicks in with a default plan. The state's Estates and Trusts article lays out a specific priority schedule.
A schedule for who inherits.
Exactly. It dictates who gets the property. The system is designed to pass assets to the closest family members, first typically starting with a surviving spouse and children. Then it might go to parents, siblings, and further out, depending on who survives.
So understanding your rights under those specific laws, if there's no will, is really vital, especially during such a difficult time.
Absolutely critical. Because it might be confusing, and you need to know where you stand legally.
So effectively, the state writes a will for you if you don't have one.
Pretty much.
And, it might not be what you actually would have wanted.
Precisely. It just follows a set legal formula.
Yeah.
That formula might align with someone's wishes, or it might not reflect their actual relationships or intentions at all.
You mentioned the Estates and Trusts article a couple of times. Is that like the main rule book for all of this?
Yes, that's the core law. The Maryland Code Estates and Trusts article. It's really comprehensive. It covers everything from what makes a will valid to the procedures for administering an estate, the duties of personal representatives and trustees, inheritance laws, the rules for trusts, guardianships. It's all in there.
Wow. Okay.
And that article is what gives the Orphans Court its legal power, its statutory authority to oversee everything, direct the personal reps, approve the accountings, resolve the conflicts.
And does it also have rules for, say, smaller estates, maybe ones that don't need the full complex process?
It does, yes. Maryland law recognizes that not every estate needs the same level of oversight. So there's a simplified procedure for what's called a small estate.
Okay. How small is small?
And a state can qualify as a small estate if its net value is $50,000 or less.
Net value. So assets minus debts.
Correct. Assets like real estate, bank accounts, cars, minus things like outstanding loans, credit card debt, funeral expenses. Now, there's an exception. If the surviving spouse is the only heir,
Yes.
that threshold goes up to $100,000.
Oh, interesting. So potentially simpler for surviving spouses in many cases.
Right. Small estates generally mean fewer court filings, less formal reporting, and they can often be settled much faster, sometimes in just a few months, compared to maybe a year or more for a larger estate.
And anything over those limits is a regular estate.
Exactly. Regular estates require more formal court supervision, more detailed inventories and accountings. Figuring out which category an estate falls into is, one of the very first critical steps an attorney helps with.
Right. And speaking of planning tools, trusts. They seem like a huge part of modern estate planning. You mentioned Maryland has specific laws for those too.
Oh, absolutely. Trusts are governed by the Maryland Trust Act of 2014. It's largely based on the Uniform Trust Code, which many states have adopted.
Okay.
This act provides a really clear legal framework for creating trusts, administering them, managing them effectively within the state. It spells out the duties of the trustees, the rights of the beneficiaries, what's required for a trust to be legally valid. It makes trusts a very reliable and predictable tool for planning in Maryland.
Okay, wow. So we've got the Orphans Court the Register of Wills, the main law and the Estates and Trust article, the whole will versus intestate path, small versus regular estates, and now the Maryland Trust Act. That's a lot of moving pieces.
It definitely is.
So when does someone typically hit that point where they say, okay, I actually need help navigating this? What are the common sort of everyday situations where getting an attorney who specializes in this becomes really indispensable?
That's a great question. It really boils down to where the rubber meets the road. People usually seek guidance in sort of two main phases: proactively, when they're planning for the future,
Right, planning ahead.
and reactively, when they're actually dealing with an estate after someone has passed away.
Makes sense. Let's talk about the planning side first. Trusts seem like a big one there.
Huge. If you want to control how your assets are managed and distributed after you're gone, maybe you want to provide for children over time, or ensure assets avoid the probate process entirely, setting up a trust is often key.
How does an attorney help with that specifically?
Well, they help you figure out what kind of trust makes sense for you. Is a revocable living trust the right fit? That's a really popular tool, specifically for bypassing probate.
Okay.
Or maybe you need an irrevocable trust for more complex tax planning goals. Or perhaps a special needs trust if you need to protect a beneficiary who has a disability. The attorney helps you choose the right structure and drafts the document correctly.
And that benefit you mentioned, avoiding probate with a trust, what's the real practical takeaway there for someone listening? Why is that a big deal?
The big takeaways are usually efficiency, privacy, and potentially cost savings. Assets that are properly held inside a trust pass directly to the beneficiaries named in the trust document.
Directly, without court.
Right, without needing public court involvement through the probate process. This is often much faster than the typical probate timeline. It keeps the details private because probate records are public.
The privacy point is significant. I hadn't thought much about that.
It is for many families, and sometimes it can avoid certain court fees or administrative costs associated with probate. But importantly, the attorney's job isn't just drafting the trust document itself.
Oh, what else?
They provide crucial advice on funding the trust. This is absolutely vital. It means making sure that your assets, like your house, your investment accounts, maybe valuable collectibles, are actually retitled into the name of the trust.
So the trust actually owns the assets.
Exactly. A trust document is just paper until it actually holds assets. An unfunded trust, or partially funded trust, doesn't achieve that goal of avoiding probate for the assets left outside.
That seems like a small detail, but actually incredibly important.
It's fundamental. Attorneys make sure that step is done correctly. Trusts are also invaluable for protecting vulnerable beneficiaries.
How so?
Well, say you have a child, or maybe a grandchild, or another loved one who maybe isn't ready to handle a large inheritance, perhaps due to age, or maybe a disability, or even just struggles with managing money.
Okay.
A trust lets you appoint someone responsible, a trustee, to manage those funds on their behalf, either for their whole lifetime or maybe until they reach a certain age or milestone.
So you can make sure they're taken care of, but without just handing them a big lump sum they might misuse.
Precisely. And this is especially critical for individuals with special needs. Inheriting assets directly could actually disqualify them from essential government benefits like Medicaid or SSI. A properly drafted special needs trust is specifically designed to hold assets for their benefit without disrupting that eligibility.
Wow, okay. That's incredibly important planning. So planning with trusts is a major area where legal expertise is key. What about the other side of the coin, dealing with the process after someone has passed? Navigating probate after a loss must just be overwhelming.
It truly often is. It comes at a time of grief, confusion. This is where an attorney specializing in Maryland probate really acts as your guide through that legal maze.
How do they help, step by step?
They assist with filing the initial petition for probate with the Register of Wills. They make sure all the required legal notices get sent out correctly to heirs and creditors. They help the person, named as the personal representative, officially obtain their letters of administration.
And those letters, that's the document that gives the personal representative the actual legal power to act for the estate.
Yes, exactly. It's their official court appointment, their badge of authority, if you will.
Yeah.
The attorney also helps figure out early on if the estate can use that simpler administrative probate process through the Register of Wills.
Right.
Or if there are complications that mean it needs to go straight to judicial probate before the Orphans Court. They prepare and file all the necessary paperwork inventories of assets, accountings of money in and out, making sure it meets the court's specific deadlines and rules.
And what about the personal representative themselves? The person actually tasked with doing all this work? That sounds like a massive job with a lot of pressure. What kind of support do they need?
It is a significant legal responsibility. They have what's called a fiduciary duty. That means they are legally obligated to act in the absolute best interests of the estate and its beneficiaries.
Okay, fiduciary duty, high standard.
It's very high standard. So attorneys provide essential advice on how to fulfill all those duties lawfully and efficiently. This involves everything from identifying and securing all the assets, maybe managing real estate, paying the deceased's final bills and debts, handling taxes, both final income taxes and potentially estate taxes. And ultimately, distributing the remaining assets according to the will, or if there's no will, according to Maryland's intestacy laws. Attorneys help navigate tricky parts, like maybe collecting life insurance proceeds, getting property retitled, arranging for sales if needed, and dealing with creditor claims. This helps the personal representative avoid making mistakes that could potentially make them personally liable.
So they're kind of like the legal co-pilot, making sure the personal representative stays on course and follows all the rules.
That's a perfect analogy. They provide the legal map and the guidance to follow it.
And what happens if that map suddenly has a huge roadblock? A dispute erupts.
Well, that's another primary reason people need an attorney who knows this area inside and out. Legal counsel is absolutely crucial for resolving challenges that inevitably pop up in some estates.
What kind of challenges are we talking about?
It could be anything. Maybe questions about whether the will itself is even valid. That's formally called filing a caveat.
A caveat, like a formal challenge.
Exactly. Someone files a legal action saying the will isn't valid. Maybe they claim it wasn't signed properly, or that the person making it was unduly influenced, or maybe they lacked the mental capacity to understand what they're signing.
Wow, those sound like serious fights.
They can be very complex, requiring a lot of evidence and legal argument. Other challenges might be disputes over how assets should be divided up, or even conflicts among family members about who should get to be the personal representative in the first place.
So how do attorneys help then?
They work to negotiate settlements first, if possible, trying to find common ground outside of court. But if that doesn't work, they're prepared to represent their client's interests and litigate the matter in the Orphans Court.
Okay. We talked about creating trusts earlier, but what about managing them long-term? Does the attorney's role continue after the trust is set up and funded?
Oh, definitely. Trust administration is an ongoing process, and trustees, the people managing the trust, often need legal support too. First, the attorney helps make sure the trust was set up correctly and funded properly to begin with.
Right, the basics.
But then, for the trustee, remember, they also have that high fiduciary duty. The attorney counsels them on all the responsibilities under the Maryland Trust Act.
Like what specifically?
Things like interpreting the specific terms of the trust document. What did the person who created it actually intend? Making appropriate decisions about when and how much to distribute to beneficiaries based on the trust's purpose and the beneficiary's needs. Keeping meticulous financial records. Providing required reports and accountings to the beneficiaries so they know what's going on.
So they help the trustee understand and actually fulfill all their legal obligations, keep them out of trouble.
Precisely. And they assist with the practical administrative tasks too. Inventorying all the trust assets, getting appraisals if needed, paying trust expenses and taxes, which might include Maryland or federal estate tax if the trust is large enough, and then making those distributions to beneficiaries in a timely and proper manner. It streamlines the whole process and helps the trustee avoid missteps that could lead to personal liability.
And trusts. They seem pretty permanent, but you mentioned they aren't always set in stone. Can they actually be changed or even ended?
They can be, yes. While trusts are often designed for the long term, Maryland law, under the Trust Act, does provide ways to modify or even terminate a trust under certain circumstances.
Like what sort of circumstances?
Well, sometimes it might be possible with the consent of all the beneficiaries, if the change doesn't conflict with the core purpose of the trust. Other times, it might require going to the Orphans Court and getting approval. For instance, if the original purpose of the trust is no longer achievable for some reason, or maybe the trust has become so small that it's no longer economically practical to keep administering it.
And an attorney would help petition the court for that.
Yes, they guide clients through those court proceedings if modification or termination is necessary and legally possible.
Okay, let's dive a bit deeper into those contested situations and Orphans Court representation. When things really do get adversarial, what other kinds of cases typically land in that court, besides the will contests or caveats we talked about?
You see a fair range. disputes over how to interpret ambiguous language in a will or trust, conflicts about the value of certain assets, sometimes challenges to gifts that were made before the person died, were they appropriate, and quite often disagreements about the actions of the executor or trustee themselves.
Ah, like if the beneficiaries think the person in charge isn't doing a good job, maybe mismanaging the money?
Exactly that. Executor-trustee disputes are common. Beneficiaries might demand a formal accounting of where all the money went. They might question investment decisions made by the fiduciary. In serious cases, they might even petition the court to have the executor or trustee removed if they believe there's been misconduct, negligence, or a breach of that fiduciary duty we keep mentioning.
So attorneys might represent the beneficiaries making the complaint or the executor defending their actions.
Both. These cases can be really sensitive, involving family dynamics, but they require firm legal advocacy based on the facts and the law.
And in all these contested situations, having someone who can really effectively advocate in court seems absolutely critical.
It's vital. You need someone who knows the ins and outs of Maryland's Estates and Trusts article, understands the specific procedures and even the local customs of the Orphans Court in those southern Maryland counties we mentioned.
Right. The local practice matters.
It really can. And someone who can effectively gather and present evidence, cross-examine witnesses, and make persuasive legal arguments to the judge. The material we reviewed from Haskell and Dyer actually highlighted their firm's approach. They prioritized trying to resolve matters outside of court. They mentioned settling a very high percentage, something like 85–90%, of estate matters without contested litigation.
Wow, that's impressive. That suggests they really focus on finding solutions first.
It does. It speaks to using legal expertise to find pathways to agreement whenever possible. But, importantly, it also made clear that they are fully prepared and experienced in representing clients vigorously in the Orphans Court when a settlement just isn't achievable, or when the issues genuinely require a judge's decision.
So, ready for court, but hoping to avoid it through skilled negotiation. Makes sense.
Exactly.
Okay, so we've explored a lot about what happens after someone passes and how an attorney helps navigate all that complexity. But you also really emphasize the proactive side, comprehensive estate planning. You said it's not just for the wealthy.
Absolutely not. It's really for anyone who owns anything or has anyone they care about that they want to provide for or protect. Planning today is fundamentally about making things significantly easier, clearer, and less stressful for your loved ones down the road. And of course, making sure your own wishes, whatever they might be, are actually honored.
So what are the key pieces of that comprehensive plan? What should people be thinking about?
Well, typically, a solid plan includes a last will and testament. That's foundational. It might also include one or more trusts, depending on your specific goals and assets. And then, crucially, it includes supporting documents for handling healthcare and financial decisions during your lifetime if you become unable to make them yourself.
Ah, you mean things like powers of attorney and healthcare directives.
Yes. I'd argue these are non-negotiable documents for real peace of mind. A durable power of attorney lets you appoint someone you trust your agent to manage your financial and legal affairs if you become incapacitated.
Okay.
And an advanced medical directive. This often includes both a living will component, stating your wishes about life-sustaining treatment, and the appointment of a healthcare proxy or agent to make medical decisions for you if you can't communicate them.
And having those documents in place helps avoid potentially needing court intervention while you're still alive, right? Like needing a guardian appointed.
Precisely. That's a huge benefit. Without a power of attorney or an advance directive, if you were to become incapacitated, your family might face the difficult, expensive, and public process of going to court to ask a judge to appoint a guardian over your person or your property. Good planning lets you choose who makes decisions, avoiding that scenario entirely.
Makes total sense. What else falls under comprehensive planning?
Well, thinking about strategies for minimizing taxes and expenses is often part of it. Maryland has both an estate tax, which applies to larger estates exceeding a certain threshold,
Okay.
and also an inheritance tax, which can apply depending on who inherits from you. An attorney knowledgeable about these specific Maryland taxes can advise on legal strategies to potentially reduce that tax burden and preserve more of your assets for your beneficiaries.
What kind of strategies?
Oh, things like how assets are titled, jointly versus individually, maybe using certain types of trusts like life insurance trusts, making charitable gifts, ensuring that beneficiary designations on things like retirement accounts or life insurance policies are coordinated and actually align with your overall estate plan.
So it sounds like all the different pieces of the plan really need to work together seamlessly.
They absolutely do. A will might say one thing, but if your retirement account beneficiary designation says something else, the beneficiary designation usually wins for that account. It all needs to be looked at holistically.
And is it a one-time thing? You set it up and forget it.
Definitely not. Because life changes, right? So a truly comprehensive approach includes periodic review and updates. Ideally, you touch base with your attorney every few years, or certainly whenever you have major life events, getting married, getting divorced, having a child or grandchild, acquiring significant new assets, maybe even if the laws change significantly. It ensures your plan stays current and still reflects your wishes.
Good advice. Okay, so just to circle back and make that distinction crystal clear for everyone listening again, estate law versus probate law. What's the simplest way to think about the difference?
Okay, yeah, let's simplify. Think of it like this. Estate law is essentially the planning side. It's everything you do while you are alive to decide what happens to your assets after you pass, and who makes decisions for you if you become incapacitated. So, drafting wills, creating trusts, setting up powers of attorney, healthcare directives, that's all estate law.
Okay, the planning part.
Right. Probate law, on the other hand, is the legal process that kicks into gear after you die. It's the administration of your estate, getting the will validated by the court, or following state law if there's no will, appointing the personal representative, paying off debts and taxes, and distributing the assets to the heirs.
Got it. Planning versus the post-death administration process.
Exactly. That's the core difference.
So pulling this all together, it really sounds like whether you're planning ahead or dealing with an estate right now, engaging a knowledgeable attorney in Maryland, particularly one who knows the specifics of those southern Maryland counties like Anne Arundel, Calvert, Charles, St. Mary's, and Prince George's is just crucial.
It really is. They function as that essential guide we talked about. They translate the complex legal jargon into understandable language and actionable steps. They help create personalized strategies based on your specific family situation and goals.
Takes the burden off your shoulders a bit.
Definitely. They alleviate the burden of managing all the technical legal details. They work to ensure your wishes, or the deceased person's wishes, are honored correctly, according to Maryland law. And ultimately, they provide that critical peace of mind that comes from having experienced legal advocacy on your side, whether that means guiding you smoothly through the administrative process or representing you effectively in court if disputes arise.
So it means that during what can be really difficult times, or even just while making these really important plans for the future, you and your family aren't left trying to navigate that dense legal forest all alone.
Exactly. Having that expertise helps ensure things are handled correctly, efficiently, and hopefully with minimal potential for conflict or problems down the road.
We have certainly covered a lot of ground today, understanding what probate actually is, the key roles of the Orphans Court and the Register of Wills, how things play out differently with or without a will.
Those key Maryland laws like the Estates and Trusts Article and the Trust Act, the difference between small and regular estates.
And just numerous practical situations where having an attorney provides absolutely essential guidance, from planning with trusts and powers of attorney to fulfilling the duties of a personal representative, navigating complex disputes, and representing clients in court.
It's a system designed really to ensure order and legality in transferring wealth and property, but it absolutely demands careful attention and, frankly, understanding to navigate it effectively.
Thinking about all this really does make you consider your own situation, doesn't it? Whether you're maybe grappling with managing an estate right now after a loss or just contemplating your own future plans, these are such profound legal and personal decisions. They impact families so deeply.
They certainly do. The ripple effects can last for generations.
So maybe let's leave you, our listener, with a couple of thoughts to mull over based on our deep dive today. First, knowing that Maryland law has a default plan if you die without a will. What might that default plan mean for the specific legacy you want to leave behind? For your most cherished relationships or assets, if you haven't clearly defined those wishes yourself in a proper legal document, like a will or trust.
That's a powerful question. And maybe a second thought. Considering all the potential complexities we've discussed, the significant legal obligations placed on personal representatives and trustees, and just the raw possibility of family disputes arising, what is perhaps one concrete step you could take, maybe even starting today, to ensure that your plans or the estate process you might be currently facing ultimately bring peace of mind, rather than creating future burdens for the people you care about the most?